Thank you, Dr. Sameer Kochar, Mr. Rohan Kochar, Dr. Gursharan Dhanjal, the Vice Chair of SKOCH Group, Mr. Ramachandran, and other distinguished participants. And last but not the least, thank you, Vrinda, for your very lavish introduction. SKOCH Group has done pioneering role in giving it back to the society. I've seen over the years, possibly decades, how Dr. Sameer Kochar has been giving it back to the society after having achieved great and unique success in his business. He performed social responsibility, that is, commitment to the society, to perfection. Today's topic also speaks about his involvement in the causes which concern India, particularly the system of administration of justice. Although the topic is arbitration in India, but in my view, it encompasses, you see, the entire system of administration of justice, because arbitration has been considered as an alternative to dispute resolution. Therefore, one has to speak about the present state of affairs so far as our justice delivery system is concerned. Therefore, it is a very relevant, important, and timely subject. It is not just like any other topic on arbitration. These days, we have seminars and conferences galore on arbitration, whether it is successful, whether there should be institutional arbitration, ad hoc arbitration, whether it is effective as an alternate dispute resolution mechanism at all, and whether it is relevant or not. But the topic today is arbitration and India. Therefore, we have to see the relevance of arbitration so far as India is concerned. We had that 1940 Act earlier that pertained to arbitration of essentially commercial disputes and all that. And it is, this subject encompasses issues such as relevance for the common man, that is the ordinary citizen of this country, so far as arbitration is concerned. And that answer is clearly that it is not relevant, you see, for the common man, because he cannot take fruit of arbitration. Second issue, essentially for corporate disputes under the existing Act, 1996 Act. It has two parts. One is the domestic arbitration, other is the international arbitration. Therefore, the common man, the common citizen of this country is completely left out of the scope of arbitration. Third, it is less expensive. Certainly not. It is monopolized and capitalized, actually, whereas it should have been open, you see, to architects, to engineers, to bureaucrats, retired bureaucrats, and all those people to be a part of the system of administering arbitration. But that is not happening. And in the hands of the judges, it has become very, very expensive. And fourth issue is whether it is expeditious. Again, certainly not. Although the new law has brought in, you see, that, okay, you must complete it within 12 months. Okay, we give you another 6 months. But then you can always approach the court to get extension, you see, because the courts are really readily, they give extensions to the arbitrators. Does India need arbitration? Or in other words, is arbitration an appropriate mode of dispute resolution? Arbitration, is it only to resolve the commercial disputes? Certainly not. Any mode of alternate dispute resolution must take in the needs of the common man, the needs of the citizens of this country, which arbitration does not. So why do we keep on discussing about arbitration? The need of the hour is to discuss litigation where common citizens and chief ministers of various states, the high courts and the states, he said there are nearly 4 crore cases. I think he's wrong because now the figure is up to 5 crore cases. 5 crore cases are pending, including Supreme Court, High Courts and District Courts. So what is being done? If we have to discuss about arbitration, first we must discuss about litigation, because in the administration, courts are also involved in the system of arbitration, whether it is a Section 9 application for interim relief, Section 11, Section 34 petitions you see to challenge the awards. Therefore, courts and arbitration procedures are intricate. Therefore, if there is a delay in disposal of cases in the courts, that would automatically impact, you see, the arbitration cases in India, particularly in India. Therefore, system of administration of justice can improve in India. Now, what are the causes and the remedies for this? That's interesting to know. The first is that we have too many laws, outdated laws. We have laws which were framed way back in 1876, 1896, 1920. All these laws are there. Too many laws, outdated laws, and there is no rationalization of the laws. In the same conference, which was addressed by the Honorable Chief Justice of India and the Prime Minister, the Law Minister said that they are in the process of rationalizing the laws, and so many laws are being obliterated from the statute book. But at the drop of the hat, at the same time, we are bringing in new laws and new regulators, resulting, you see, in increase in litigation, increase in disputes. With every new law comes, you see, it is good for lawyers, but certainly not good for the economy of the country if you have too many laws. Another factor is poor infrastructure. That also the Chief Justice highlighted. And courts are working at half the strength. Has to take the call. The President of India has to issue the warrant of appointment. Therefore, some delay in the procedure for appointment. So we can reduce pendency of cases if government has to take a positive, constructive view. Very well, the government loses in the court of first instance. It's a very important question of law. They will not go in appeal. It almost 60 justice made a very significant point. That why can't you see these public sector undertakings, the ministries and all, they evolve a system that very well, let us avoid going to the courts. We can settle the matters. I remember when I was representing, you see, a public sector undertaking, there was a dispute construction with a construction contractor while constructing, you see, the Centaur Hotel in Bombay. So I told them, I said, you have a weak case, so why don't you try to settle it with the other side? They said, sir, we can't settle it. But today, if we settle the matter, tomorrow there will be a CBI inquiry as to why you have settled the matter, why you have not allowed the court to proceed. If whatever the court says, we will pay. But we are not going to enter into any settlement with this. Now, this is the type of approach which the government officials and particularly those in the public sector undertaking, they have. So some soul searching has to be done by the ministry, by the government as to how disputes can be reduced. That is why when we talk of settlements as arbitration, the government has to take the lead. As I said earlier, Section 9, Section 11, Section 34, Section 37, everywhere the courts are involved. This stranglehold of the courts is there on arbitration, and that results not only in inordinate delays, but also in lot of expense. Because if some matter goes to the court, then court is not bound by that limit of 12 months or 18 months and all that. Court may take its own time to settle, to decide about the matter, because it has to adjudicate upon it. And looking at the situation as it is, particularly in Delhi and Bombay and other high courts, it is impossible to get a positive award, to get an award which is enforceable from the arbitrators. So what is the remedy? The remedy is to go back to our ancient practices. Consensual form of justice. Our emphasis has to be on justice, because our constitution says that we, the citizens of India, give to ourselves this constitution which lays down that our citizens will get justice, social, economic, and political. That is in the preamble of the constitution. But in the body of the constitution, the word justice is consciously missing. Emphasis then turns to law. Who can make the laws? Center will make these laws. States will make these laws. There is a concurrent list. Emphasis shifts to law and the technicalities of law. Justice takes a back seat. Therefore, that is how this adversarial system of administration of justice came into this country, brought in by the British. Before that, we had the panchayat system here at the villages. All the differences used to be resolved. Then we had the Zilla Parishads at a higher level. All the dispute used to be settled. Even during the Mughal times, the Mughal kings believed in justice, what is called Adl-e-Jahangir. Adl means the justice, Jahangir's justice. There were no laws, no technicalities. You used to stake what is just and proper. But we have now a system and we have to live with that, because there is our constitution which gives sanctity to the framework of our system of administration of justice, which is 3-4 tier, possibly 5 tiers, starting with the court of the sub-judge, it goes to the senior sub-judge, it goes to the district judge, it goes to the high court, it goes to the revision bench, then it goes finally to Supreme Court. In Supreme Court rules, you also have a review, then you have curative petitions. All these are their adversarial system of law, little emphasis on justice. So in order to go back to our system and within the present framework which our constitution provides, there is still a way out. And that way out is mediation. Mediation is the answer, not arbitration. Settle your disputes. And I always tell my clients, and I've been doing so for the last 60 years, that a bad settlement is better than successful litigation. Therefore, mediation has to be promoted. That spirit of promoting settlement has to be inculcated, and that can be done. Our mindset has to change. And instead of bringing new laws, one should encourage, mediation. That is also self-regulation. Government should have confidence in the stakeholders, in the business leaders, that they can set up their own regulations and be governed by those. We have seen that in the Advertising Council of India, where all their internal disputes are settled and all that they are done. Therefore, even at the education level, university, law schools level, what has to be inculcated is a spirit of negotiations, negotiation skills. They have to be taught to the students of law, which would help them in then resolving their differences with the opposite parties in their business transaction, in the matters of interpretation of contracts, so that settlements could be successfully negotiated. Our court system has to be brought back on rails and mediation has to be promoted. That is my humble suggestion. And in order to bring back our court system, which is interconnected with arbitration, because eventually arbitration awards can be enforced if Section 34 applications, petitions, you see, they are decided. Therefore, in order to do that, the government should act, reduce the number of cases, don't bring in new laws just for the sake of it, remove all the obsolete laws, overlapping laws, outdated laws from the statute book. Let there be a rationalization, you see, in that. So that is my humble submission for your consideration. And I congratulate India Law Forum and the Scotch Summit for giving me this opportunity of sharing my views with all of you. Thank you.